My lord, that immediately leads to two submissions. Your lordship, in my research, I have not been able to find out, but your lordships may be aware better than me that I could not find a case from any common law jurisdiction where, as a result of a civil liability and a decree of a civil court, a citizen is denied the right to exercise or the protection of a fundamental right guaranteed by the Constitution for the rest of his life. Criminally, in criminal law, it may happen.
About a banking case.
My lord.
How about a banking case?
My lord, yes.
The banking case, he's declared
my lord, yes.
debtor.
Now, the question is,
the law says that if you're a debtor, till you are a debtor, your disability is there, till you clear the debt.
Correct, my lord. Your lordship is absolutely right, and that is why your lordship will find that insofar as that is concerned, that is reflected in Article 63 of the Constitution. And Article 63 talks about, one, the debt having been outstanding for a particular period of time, and till such time that it is paid. The moment that debt is paid, debt is removed. I was talking of a situation where a civil liability results in a person being deprived of his right forever. Because in this case, my lord, in the case of a debt, as your lordship has rightly identified, or utility bills not being paid, the moment they are paid, the debt is met, the person is eligible. In this case, what does he need?
In this case also, they say that till that decision is there, you remove that decision, you challenge that decision, set aside that decision, and your disability goes with it.
My lord, their lordships say that determination taking place from a court of final determination. Let us say that, first of all, my lord, which court is capable of granting a declaration under the civil laws of the country, whether it be a Section 42 court or a Section 9 court or even an Article 199 declaration, that a person is sagacious, ameen, righteous, non-profligate. Because your lordships generally grant declarations about a legal title or a legal character. There is no civil court in this country which can grant that. My lord, now let's turn to the election laws. The civil court under the election law.
One question, Mr.
My lord.
The two questions rather. One is that whether the civil court has the jurisdiction to grant negative declaration, and number two, whether that court has the jurisdiction to fix the disqualification of a candidate.
My lord,
for a certain period or even for life, whether the court has power.
My lord, my submission would be that the reason why a civil court can't do that is twofold. Number one, the civil court is unable to do that because of the language of Section 42 and Section 9 and Article 199. And the second is that such an issue, when it arises particularly in the context of an election, because the issue of qualification or disqualification will only arise in the context of an election, that jurisdiction is completely ousted by Article 225 of the Constitution and the judgments of your lordship. Your lordships have said no election will be called in question. The meaning under Article 225 of the Constitution, and your lordships have said in Javed Hashmi's case that that election starts from the time the Election Commission notifies the schedule till such time that a candidate is declared, returned or elected. The decisions of the election tribunal, your lordship have said in Raza Hayat Hiraj's case, cannot be called in question even in a writ petition.
Prior decree B cannot be used.
My lord,
suppose there is a prior decree before the start of election that cannot be used in the...
My lord, the prior decree will only say whether I have paid my debt or not. Now, in that case, as my lord, Mr. Justice Yahya Afridi identified, there will be a disqualification attracted under Article 63 of the Constitution. No declaration under Article 62 of sagaciousness or righteousness. My lord, which, your lordships with your vast experience in civil law, which civil court, when passing a decree, even in a banking suit, and says this money is outstanding, then goes on further to declare that this person has ceased to be sagacious,
So that's the question, can you just go back, Mr. Makhdoom?
My lord.
We cannot attribute redundancy to the Constitution, even though it's quite clear that there's no such declaration that can come from any court, but we have to give meaning to because we can't just throw it out. So making an effort to giving it a meaning, this paragraph is crucial in Samiullah, that the declaration they're talking about is arising out of civil jurisdiction, inter-party litigation. So, for example, there's a case where a sale deed has been struck down as being fraudulent or forged. Now, there it has been, as a consequence, we understand that that person has committed fraud because he came up with a fraudulent sale deed. That is a bit of a construction that we have to do just in order to justify this declaration given in the court. Having said that, all the other declarations which are coming in through original jurisdiction and the writ jurisdiction not arising from civil jurisdiction are out of the canvas, right? So let's first specify that the declaration we're talking about is inter-parties arising out of civil litigation.
Right.
Now, in the absence of 232, we would have had to construct what is to be done. I'm just saying that legislation could, not justifying 232, but legislation could say that for the purpose of election, such a civil, such a decree which is arising out of civil litigation could have a time frame for purposes of election. So the question is, can legislation put a time frame on this declaration? Could that be possible? Not the way it's worded in 232. My question to you is that, first of all, Samiullah Baloch helps us identify that which declaratory decrees we talk about, which declarations are relevant. Declarations arising out of civil jurisdiction, which are inter-parties, number one. Now, could legislation, not the way it is done today, but could legislation say that this declaration will continue forever between the parties, but for the purposes of election will have a time frame?
My lord.
Such a legislation is not the way it is done now in 232, but could such a legislation be possible to say that a declaration inter-parties arising out of civil litigation for the purposes of election would only be for 5 years, even though between the parties it will remain forever till it is set aside, but for the purpose of election? Could such legislation take place?
My lord, that was a bit later, but may I address it right now? My lord, when your lordship looks at 62(1)(f), the constitution makers under the 18th Amendment do not say that this is a declaration of a civil court. They say no declaration to the contrary by a court of law. A criminal court is as much a court of law as a civil court. Now, if your lordship reads a court of law as a court of law, a court of plenary jurisdiction, that would include courts both on the civil and criminal side which decide cases after recording of evidence. And in that, if your lordship does that, then 63 and 62 will have to be read together. There's no way one can read them differently. My lord, may I just preface this a little further? Sure. My lord, a question has been asked and repeatedly that, and my lord, Mr. Yahya Afridi asked that again yesterday. Why have two lists? Justice Hilali asked the same question again. Why have two lists? What's the difference? My lord, the two lists made perfect sense under the original 1973 Constitution. The list of qualifications was that you should be a citizen of Pakistan. For MNAs, you should be 25 years of age. For senators, you should be 30 years of age. And that is where the qualifications ended. All three were qualifications. The disqualifications were that he is of unsound mind, that he is an undischarged insolvent, or he ceases to be a citizen of Pakistan or acquires the citizenship of a foreign country. When your lordship looks at them, there is no disconnect.